Hi, this article is about planning for your children in the event of detention or deportation. No parent ever wants to be faced with the possibility of being separated from their children. The fear that generates can easily freeze you into inaction. Unfortunately, the current environment in which we live doesn't give you the luxury of inaction. This means that if you are in a mixed status family, you must ensure your children have a trusted caregiver in the event that you are detained. The caregiver is a person who can make healthcare and education decisions for your children. In addition, you will need someone who will be responsible for the financial well-being of the children. You should make these decisions and complete the necessary forms with the help of an immigration attorney or a trusted advisor. In New York State, there are two alternatives for trusted caregiver. The first is a designation of a person in a parental relationship. The second is a standby guardian. To provide financial support, you will need to appoint a power of attorney. Of course, you need to make sure the person you choose is willing to care for your children. Even more difficult, if your children are old enough to understand, you need to talk to them about your plans. For the trusted caregiver, you can choose any adult regardless of their immigration status. You still maintain your parental rights and the arrangement can be canceled at any time. So now let's talk about the differences of each type of caregiver and the advantages and disadvantages of each. Designation of a person in a parental relationship or a parental designee gives a trusted person limited power to make decisions about your child's education and health care. For instance, the parental designee can make decisions about the child's daily routine, school activities such as enrolling in school or absences from school, and for routine or emergency medical care. You can prepare the form now, and you can have it activate automatically upon detention or deportation. At least one parent must sign and notarize. The arrangement is valid for 12 months from activation and can be renewed by signing a new document. Another option is designation of a standby guardian. This provides more powers than the parental designee. The standby guardian steps into the parent's full legal role. For instance, they can authorize major medical treatments such as surgery and approve the child's travel, which a parental designee cannot. The standby guardianship activates when there is an administrative separation, such as a detention, deportation, or receipt of official notice of intent to deport. However, 60 days after activation, the standby guardian must formally apply to a family or surrogate court and be appointed by a judge. The judge could require the proposed guardian be fingerprinted and have a background check. You should also complete a waiver so the court doesn't need to provide you notice about the guardianship proceedings. The waiver also confirms to the court that you agree with who is the proposed guardian. Neither of these arrangements can manage money or property of the family. This requires a power of attorney that grants access to bank accounts, can pay bills, etc. Even if you take this step to appoint a parental designee or standby guardian, it is a good idea to check with your child's school, medical provider, and any other places that your child regularly goes if they will accept these documents or if they have their own forms to complete. Alternatively, you should consider whether you want your U.S. citizen child to be deported with you. If so, you should consider writing and signing a statement expressing these wishes. As you try to make crucial and difficult life-changing decisions, it is so important to get an attorney or a trusted advisor involved. For links to some possible resources, you can contact us at indivisible845.immigration@gmail.com. Thank you.